Hello, Sofa Squad. How's everybody doing? What's going on? How are y'all doing? Hold on one second. I'm streaming. Okay. How's everybody doing? What are y'all up to? Now, y'all, we got to figure out this out. So, if you're watching on the replay or if you're joining now, we are going to be watching, hopefully. We're waiting on the Chad Daybell trial to start. So, I'm off today, so I figured we can put in a little bit of time here, hang out, just see what's going on in the beginning, kind of a thing, and talk about it and whatnot. So I'm hoping that I'm very eager to see, obviously justice, but just to see him get carded in there. Now, what I need to do is make sure that my volume's off. Okay, over here. Yes. What's this? No. Yep, don't need that. Nope. StreamYard is where y'all are at. Yep. This is what we're waiting on. And this one, once it starts up, I'll have y'all kind of help me with the volume thing to make sure that we're hearing things correctly and all that stuff, and no feedback and yada. So, anyways, how is everybody doing? What's going on? Hey, Christina. Hey, Mel. Hey, Jody. Hey, Jenny. Hey, Audra. Hey, Amy. Hey, Regina. Hey, Marbear. Hello, Jennifer. Who else is in here? Hey, Mark, how's it going? Good seeing you. Yeah, so we're just kind of waiting. We're just kind of waiting to see them come up, some action. They got the little screen going there. So, hey, Mama P. Hey, Carrie. Hey, Verna. Hey, Jessica. Hey, John. What's going on? Hey, Jason. Hey, Kim. Hey, Isabel. Dragonfly. I usually send the back. Hey, old soul. How's it going? Hey, Regina. 1:30 a.m. in Australia. You're in it to win it there. I hope everybody's doing well. Long time no see, right? That was a fun live last night, going over the things. I'm going to record hopefully the last installment of the diary entry for the journal entry for the other case we're following, Ruby. They're so similar, right? The Daybell thing. So hopefully that'll be up tomorrow. So what I'm going to do is we're just going to kind of hang out here. I've got a couple hours this morning, so I figure we watch the beginnings of it. This is, of course, if it starts on time and all that kind of stuff. So hopefully that will take place. What will happen is we'll see how long it goes and whatnot. Again, this is all in the presumption that it starts soon. I mean, again, knowing me, what will happen is by the time I have to go, that's when it'll start up. But that's fine. There's some other channels, lots of channels doing it. Gigi's doing it. Kresha's doing it. Obviously Judge Boyce's channel, Law and Crime. So yeah. Anyways, my understanding is 9 a.m. their time. And so for those just joining whatnot, we are going to be watching, or what we're looking out for, I should say, is Chad Daybell trial is starting. Now, remember, Lori Daybell, I hate even saying his wife, but his wife, she's already been convicted on these crimes. She's now facing more in Arizona. So it's Chatty Boy's turn. The death penalty is on the table for Chad. In my non-legal, non-professional opinion, I don't see how he will slither his way out of this. Okay. So there's that. Yeah, so we'll see. That's what we're just going to kind of wait and see here. Now, what we're going to do also is I've got my little telephone. Emily says hello to everybody. Let me just say thank you. I hope your day's going well too. Your day is well too. I've been following Nate Eaton on I don't know, what do you call that? On the Twitters, or formerly known as Twitter, I should say. I'm sorry. Let's see. Where is he? Where is our little friend Nate? There he is. Okay. Okay, so 1 hour courthouse. Okay, so Nate says this is an hour ago. Courthouse jury opens at 8:45 a.m. Jury selection begins at 9. John Pryor, Daybell's attorney, was behind me in the security line. Tried chatting with him. He responded, "I can't say a word." Now, if you remember, the judge, obviously John Pryor knows who Nate Eaton is, right? The judge did a gag order because John Pryor was talking to the media, which just blows my mind. But I mean, I guess not. So very recently, the judge did a gag order on stuff and was like, nobody can talk about anything, nothing at all, yada yada. Right? I get it. I think it's funny he said that. Okay, so I'm just going to keep reading Nate's text while we sit here and wait. So 32 minutes ago, Nate says, Vicky Hoban, Tammy Daybell's aunt, is here. Now, for those who are unfamiliar with this case, yes, it is jury selection today. Also, we're not getting to the trial, so that's why this could not really even happen. You know what I'm saying? I'm not saying the trial's not going to happen, but first day of stuff is very complicated. So, so just know that. So Tammy Daybell was Chad Daybell's wife. She mysteriously passed away under very bizarre circumstances, which paved the way for Chad and Lori to unite their love and distortion. Cannot roll my damn eyes hard enough. So that's who we're referring to here. And her aunt is there. So Nate says there's about 5 to 10 members of the public, several members of the media. We are waiting for the courtroom to open. Now, 1 day ago, okay, never mind that. We don't need to know about that right now. Okay, so let's read very quickly what Nate says about the thingamajig, the gag order. So it says, this is 3 days ago. Judge Boyces issued a non-dissemination gag order in the Daybell case after John Pryor did a TV interview. It prohibits attorneys from making written or oral statements about the case until April 15th or after opening statement. So there you go. So that's where that came from. So let's go see what Brian Enton is doing. Let's see. Is he out there? Boom, boom, boom. Let me say, wow. No. Okay, nothing really going on with Brian. We're going to go back to Nate, though. And now we'll come back to the chat room. Hey, Aaron. Hey, Samantha. Hey, Kim. Hey, Calamity. Hey, Elon. Hey, Nikki. Hey, I. Hey, Leah. Hey, Artie. Hello again. Mel. Oh, wait. Let me refresh. Hold on. Please hold. No, nothing. Okay, let's come back over here. I hope everybody's doing well. Vibe says, I hated going through jury selection and not being chosen. Amen, right? Hey, Cam, how's it going? Hey, don't panic. I hope everybody's doing well. So let me put a little thing up here in StreamYard so that I won't keep saying it, because I feel like I have to, when more people come out, I need to, you know what I mean? Announce everybody. Let's see here. Example channel. Well, now, hold on now. Rename folder, duplicate. Well, no, now. We want to make one. Wait, I didn't mean to put that one up. I mean, but thank you to the mods, but Lori says it's starting. Whoops. Okay, hold on now. Oh, whoops, I'm sorry. I read something wrong here. I read somebody else's text. Okay, I was trying to do a banner to say, please hold. Okay. So we're going to say Chad Daybell, jury selection, day 1. Create banner. Save. Show. Yeah, cool. Okay. So then let's come back over here. Boom, boom, boom. Let me hear say wow. Let's see. Hello, everybody. Let me just get back up to the comments here. They're like, I didn't play. Oh, I know. I like that too. How many people are waiting to watch the judge's channel? Yeah, that's where. Absolutely, no problem. I'm glad it worked out this way. Again, we'll just go for as long as we can. I basically have a couple hours this morning, so I figure we jump on and talk about it and watch. But again, that's contingent upon it starting early. So I was saying earlier, kind of the way things go with me is what will end up happening is I'll probably have to go by the time they start, right? But yeah, so I had the day off and I kind of got a bunch of stuff done this morning. So I was like, well, let's hop on here and let's just see what's going to happen. And so that's what we're doing. So we'll kind of just sit here and gear ourselves up for it. It's been a long time coming, y'all. This has gone on for years. Oh my gosh, this case is just, it's absolutely horrifying. I remember when this first started coming about, and at the time we had a friend named Denise who, if you look at the credits, and again at the very end it's saying loving memory of Denise, that's who this refers to, and she was telling us about it. And I remember thinking like, God, that's so bizarre. But at the time, like Letitia Stout, all these crazy cases happened, right? And she was like, I think this is going to be one of those like absolutely horrifying, crazy, whatever. And so she was like looking into the people behind it and all this stuff. It was crazy, right? And she was right. She was right. She was right. Oh, thank you, PTSD. I appreciate it. Hey Audrey, how's it going? No, I know, right? Elon, there's literally yeah, I'm kind of surprised. Like, so at chat, I'm not sure what the deal was. Why? Hey, Chrissy, what's up? Good luck today, Chrissy. Um, I'm not sure what the deal with Chad, and probably more people like channels that have gone real in depth with it, or lawyer channels might be able to speak to why he didn't just take a plea deal, or maybe they didn't offer it to him. You know what I mean? Maybe they want him to get the death penalty. I mean, it could be, you know what I'm saying? I mean, God knows, I think we all do, right? I mean, let's be honest here. Um, let's be honest. Oh, see, Cal Gal says that's how I found you, Rip Denise. I know. God bless her. I mean, that was just so sad. So sad. Able to hide down. I know, right, Joe? A lot of people really remember her. She made such an impact. She was such a wonderful soul. Um, but yeah, so she is. She's how she informed me about this, and she was damn right. It was next level. Okay, next level. Um. So that being said, let's see what Nate's saying on his thing real quick. Let's see here. Oh, Nate. Okay, so here he goes. 19 minutes ago. Oh, we've got some update. We got some update. Come on, oh Nate, and you can count on him. Okay. He says 19 minutes ago, he says it's day one of jury voir dire. I can never say that right. In the Chad Daybell case, voir dire is a preliminary examination of a witness or a jury by a judge or counsel. There are about 20 people in the courtroom gallery, including public, media, etc. 16 minutes ago, Chad Daybell is dressed in a light blue shirt, khaki pants, and a tie, alone at the defense table. His attorney and prosecutors are meeting with Judge Boyce in chambers. Okay, so they're in chambers, probably like, can you imagine they came out and said we reached a plea deal? I would just be like, what? Oh man, I wish they would show him to us. But so Larry said, and another thing that Nate said, Larry basically was like, Chad still has the same spineless demeanor that he's always had. So shocker, right? Um, not the portal. The things that we have had to say and learn in this case, y'all. So the horrible part of it, right? Of what they did and whatnot, and that's obviously horrible. But then this whole thing of portals and distortion and loin fire and the whole 9 yards. I've never in a million years thought I would know some of the vocabulary that I've learned from this trial, or this case, I should say. It's just next level. Um, Yeah, Dragonfly says they need to do a complete investigation of all the people's children or parents involved with connections. Amen. Amen. Voir dire. Thank you, Iona. Voir dire. The storm. Oh, God. Yeah, the storm. I forgot about that. So cringy, right? Nicola says, don't forget the storm. If you've. Oh, wait, hold on. We got action. Plays hold. Plays hold. Good Lord. Something's going on. Oh, my God. Yeah. Okay, here we go. Here we go. Now, when I hear it talk, I'm going to see if y'all can hear it too. There's Chad. Now, they're not saying anything yet, y'all, but when they do, I'm going to check with y'all to make sure you can hear it. And I might mute myself. You see what I'm saying? And then come on, like if we're going to talk or whatever. Oh, my God.
All right, good morning, everyone. We're going to go
Can y'all
on
hear
the
them
record
talking?
now. We will not start the broadcast here for a moment while I make a few.
Okay, so y'all heard him. Okay, so did you hear him say that? He was like, we're not going to start the broadcast, and they took it down real quick. I mean, y'all, my gosh. Yeah, Chud is 100%. So they've gone away again. We're going to wait again for a minute. Oh my God, my heart rate, y'all. Oh my God. They just took it down. So Jennifer, it sounds like the judge was basically like, don't broadcast it yet, and they took it down. They being the power, whoever's controlling this at the courtroom. I know Kelly says that was a big tease. I know, right? I'm over here like dying, right? I am stressed out. It's got me stressed, y'all. Hey Wilma, okay, we won't tell. Just creeping. Nothing's happening right now. They came on for a second, and then they went away because the judge was like, "We're not broadcasting yet," and they went away real quick. So, so yeah. I know we need a GoPro. You know what I saw earlier? I was going by the gas station. It's one of those Google cars, you know what I'm saying, that does the maps or whatever. It has a thing on it. I was like, you just never see one like getting gas, or it's like rare to even see one, right? Let alone like getting gas. I wanted to go up and like do something, but obviously it wasn't working at that point. Yeah, we know the stream's working. That was a test. It passed. Um, Chad is loin fire. Chad is his given name. Testing, 1, 2, 3. Hey Melissa, they came on for like a split second, and then we're like, okay, the judge was like, we're not broadcasting yet, and they took it down real quick. I don't know. Has anyone here heard, has any of his jailhouse calls been released? Oh my God, you got a GoPro for your dog. I would love that. That's so cool. Roscoe's would be really boring at this point because all he would do is follow me around the house. You would literally just see my feet, and that's it. He probably does very complicated stuff when I'm not here, but when I'm here, that's all you would see. No, Paige, I have not been. I didn't even know he was getting sentenced this morning. Paige says, have you been paying attention to Alec Murdaugh's sentencing this morning? No, last I saw it was like he had violated his plea deal. Alex Murdaugh. So let's see here. Say he failed the polygraph test. I mean, but at this point, y'all, I mean, he's already served a life sentence for the murder. Yeah, I mean, it's like, I mean, stack him on if you have to. You know what I'm saying? But of course he lied. You know, I mean, what do you expect? You know what I'm saying? Yeah, Roscoe GoPro will be cute. Maybe, and don't let him hear this. Maybe my next dog, I'll get a GoPro. GoFundMe for Roxy's GoPro. It might be too heavy for his head. He would probably just be like, boom. He'd try and stand up and just fall right over. Yo, I can't believe this. I mean, they really did tease us, y'all. I mean, come on now, Judge Boys. It's like we're being punished or something. Kelly says, so Paul, are you honestly telling us that you have never referred to yourself or anyone else as loin fire? I might need to from now on, right? Just the name sounds just like loin. You know what I'm saying? It's like a loin. I'm just like, oh my God. That is like the last thing. Like if somebody's trying to talk like romantic or sexy or dirty or whatever, it's like this is missing the mark, right? The word loin does not need to be present, okay? It's kind of ruined the food too. Yeah, RD says tenderloin. Even at this point, I pass it by in the damn grocery store. I'm like, I just can't. Regina, you were right. Okay, literally, when you say loin, it's like loin is like hand in hand with the word moist to me, right? Where it's like you say, and it's like I don't know why it just feels wrong. Right? You got my loins on fire, baby. It's like, are you being serious? Like that's something you'd have to be like, are you being completely serious when you say that? Yeah. Okay. Flaming loins. Loin is such a good. I know, right? It's so funny how we all like associate it with that. Called sirloins. Oh my god. They need to open one in Utah called Loin Fire. Because isn't that where isn't it derived from it's something with the religion that they belong to? Or is it literally a Chad Daybell thing? I don't know. Loincloth before. Okay, isn't that where that's where it comes from, right? So I hated the term loincloth before he sent it to the grave. Before and he's into the grave. Yes. I think that's where it derived from is loincloth. And so then with him talking like it was a naughty thing, maybe it's a religion thing. Okay. So almost like, yeah. The storm's loin fire made moist. You got Nicola got all the words into one sentence there for us. All the cringe things done up in one sentence there for us, right? Okay, let's go see. Let's go refresh. Okay. Stormy loins. It's unintentional loin fire. Christine, we need some water. Stat. Oh my gosh, this is too funny. It's so funny how. I can't see Chad's fave music. Well, the one thing too is like when you see this is the thing. Like when you want to look at like what what's her name, Lori like went after or whatever with Chad. It has to be like status, power, those kind of things. Like she looked at it like, oh my gosh, like he's like this figurehead in this tiny little clique, right? Um, and she wanted to kind of do that because if you just went based on physical appearance, it's like, I mean, come on, I'm not trying to be like, a bitch about it or anything, but I mean, let's be honest here, y'all. I mean, Chad's not you know what I mean? It's like, girl, what? You know what I'm saying? So I think that that's what she was after with him. I think, look, he could have looked 10 times worse than he does. You know what I'm saying? Because again, it's just like, there's that, but also, so here's the thing too. You know how like someone's personality, like you could have somebody that if you just visually look at them, you might be like, but their personality can make them attractive. Like it can make them hot or whatever. Okay, here we go. Chad doesn't even have that going for him. Okay.
All right, good morning, everyone. We're on the record on Fremont County case CR 2221-1623, State of Idaho versus Chad Guy Daybell. I'll note that the attorneys are present. The state is here represented by the prosecution, the defense, and the defendant. I'll further introduce them in a moment. Is the state ready to proceed this morning?
Yes, Your Honor. Thank you.
Is the defense ready to proceed?
Yes, Your Honor. Thank you.
Thank you. Before we begin with further voir dire examination, let me inquire of the state, is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor.
Any objection from the defense?
No, Your Honor. Thank
Thank you, counsel. Ladies and gentlemen of the jury, then thank you for returning this morning. You've been recalled as prospective jurors in this case now before us. I'll again reintroduce my court staff. My name is Stephen W. Boyce. I'm the district judge of Fremont County, Idaho. I'm in charge of the courtroom in this trial. Court clerk here assisting today is Shannon Holstein. She's taking minutes of the proceedings and will be administering oaths to you this morning as well. The marshals here assisting with courtroom order and helping the jury movement are Steve Holmes, Ken Daish, and James Ravello. Court reporter this morning is Mary Fox, who's taking a stenographic record of everything said during the trial proceedings. And my staff attorney is Courtney Stallings, who's seated to the far right over there at a table. She assists me from time to time with legal research and administrative issues. Each of you, 16 jurors here, have been qualified to serve as a juror of this court, and each of you filled out a questionnaire that's been reviewed now by counsel in the court, and it was determined to recall you for further questioning. The thing we're doing in this trial at this stage is to select a total of 18 jurors, comprising 12 jurors and 6 alternates from among you. At this time, the clerk will now read a roll call of the jury, not referring by name, but referring by your red card number. So I'll have the clerk do that. If you would just hold your number up once your number is called, we'll make sure we all know where you're seated and that this is the proper seating for this group.
Once I call your number, if you can audibly answer that you're present. Juror number 11. Say present.
Present.
Juror number 27. Present. Juror number 31. Present. Juror number 41. Present. Juror number 48.
Present.
Juror number 56.
Present.
Juror number 67.
Present.
Juror number 121. Juror number 146. Juror number 186.
Present.
Juror number 219.
Present.
Juror number 249. Juror number 296. Juror number 321.
Present.
Juror number 348. Juror 394.
Present.
Thank you.
All right, to assist you in understanding and participating in the jury selection process, I'll now reintroduce you to the parties and their attorneys and briefly summarize what this case is about. When I introduce an individual, please stand and briefly face the jury panel, then we'll take your seat. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state's represented in this trial by Lindsay Blake, Fremont County prosecutor. Rob Wood is the Madison County prosecutor, and special assistant prosecutors Ingrid Beatty and Rocky Wixom. The defendant in this case is Chad Guy Daybell, who's represented by his attorney John Pryor. This case is a criminal matter, which means the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the amended indictment, and you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho alleges that Chad Guy Daybell committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception; count 2, first-degree murder; count 3, conspiracy to commit first-degree murder and grand theft by deception; count 4, first-degree murder; count 5, conspiracy to commit first-degree murder; count 6, first-degree murder; count 7, insurance fraud; count 9, insurance fraud. Mr. Daybell has pled not guilty to these charges. Please remember, this is simply a description of the charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. Duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. This time, I'll instruct the clerk to administer an oath to the jury panel. The clerk will now swear the entire jury panel for this voir dire examination. If each of you would please stand and raise your right hand.
You solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God.
Thank you. Please be seated. I'll note that each juror took the oath just now. Clerk has impaneled 16 prospective jurors for questioning in small groups today. We've gone through their roll call as well. At this time, I'll ask the state, will the state stipulate that the jurors were properly called and impaneled today?
Yes, Your Honor, thank you.
Will the defense stipulate as well?
Yes, Your Honor. Thank
All right, thank you, counsel. Next, I'll inquire of the marshals here. I did require that the jurors complete a jury affirmation that they've not gone back to review or investigate the case since they filled out the questionnaires. Did each juror complete an affirmation?
you. Yes, Your Honor.
Okay, thank you for following the court's admonishment and completing your affirmation today. In this part of the jury selection process, then you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law. In Old French, it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter of this trial. The object is to obtain 12 trial jurors who will impartially try the issues of this case upon the evidence presented in the courtroom without being influenced by other factors. Please understand this questioning is not for the purpose of prying into your affairs for personal reasons, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please raise your hand. When called upon to speak, please identify yourself by that red card number you have. Because these proceedings are being stenographically recorded by a court reporter, also please speak clearly and give audible answers such as yes or no, rather than, for example, nodding your head. In addition, please wait for the person you are addressing to finish the sentence before speaking, so the court reporter doesn't have to deal with two people speaking at the same time. Importantly, if you have any answer to questions and other questions I'll identify that will either be embarrassing for you to answer publicly or you think are best answered in a more private setting, the court will arrange that. Similarly, if you have an answer that you think could prejudice other prospective jurors, for example, of information you may know about this case, please refrain from discussing that in front of the other jurors, and we will talk to you about that individually as well, outside of the presence of the other jurors. As I mentioned then, if you have knowledge of this case from pretrial media or coverage or publicity, please don't discuss any specific facts of that in front of the other jurors. And there is a special instruction that's been given in this case, which I'll now give to each of you together. And the special instruction is as follows. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I would also instruct the attorneys for both parties to avoid repeating any questions already asked by the court. The attorneys do, however, have the right to direct follow-up questions to a juror regarding a juror's response to the court's previous questions. The jury should be aware that during and following this voir dire examination, one or more of you may be challenged. Each side has challenges, what are called for cause. That means they can ask that a juror be excused for some specific reason. Later, there will also be what are called peremptory challenges, and that means each side can challenge a juror and ask they be excused without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel your honesty or integrity has been questioned, because it is not. I'll now begin the court's portion of the voir dire process, after which the attorneys for both parties will be given an opportunity to make their own voir dire inquiries. Those of you who are not called should pay close attention to the questions being asked here, because you may be later called upon to answer those same questions. First question I'll ask you all as a group, when you completed your questionnaire last week, I'm going back to that. Are the answers given by each of you in the jury information forms true and accurate still? Okay, everyone's answered affirmatively. Let's next talk about the issue of the time commitment that may be required in the trial in this case. If you are required to serve as a juror here, it will be for a period of approximately 8 to 10 weeks. Would this time frame create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case? Is there anyone that has a response for that question? Yes. Okay. Please raise your red card. Juror number 249, express your concern, please, regarding the timing of the trial.
My work only allows approximately 80 hours of time. After that, it will be all entirely work, or excuse me, happily paid.
Okay, and are we gonna have a roving microphone perhaps for jurors? If not, we can get one set up for the next group. Juror number 249, I was able to hear your concern about limited time frame involving work. Have you had an opportunity to discuss if they've got any other policy, if you are in a longer trial such as this case, that may allow for additional time off if you were required to serve?
I did read the policy, but because I just found out about this late last week, that I was selected. I simply went online for our policy, team member handbook, and read up on it because I was concerned that this was going to be a long time. So I double checked the policy, and that's what it states. 80 hours.
All right. Given the concern at this point, let me pass over first to the state and the defense. If you have any additional voir dire at this time, specifically on the issue of a potential hardship for juror 249.
And Your Honor, the state actually did have a question regarding a potential hardship with regard to juror 249. It's one that hasn't been talked about, but on the questionnaire, there was an indication that there was a May camping trip planned, but we just didn't have a lot of details. So we had actually planned on inquiring further regarding that hardship.
Okay,
Or the court wants to get into that. The state does not have an objection given what he's indicating his work policy is either.
okay, well, I'll allow you to return to that issue then in your individual voir dire. Juror number 249, I'll let the attorneys come back to you in their portion of voir dire to further question the hardship issue you've raised. Is there anyone else that would also express a concern of hardship if they were required to serve for that time frame?
Yes.
Okay, we've got a few more. Juror numbers 67.
I'm a sole provider in my family. My wife has an autoimmune disorder, and so. Check. It would be difficult for me to do this, and I'd be losing out on a lot of money, and my job also would probably lay me off because I'm an alarm operator and they're already short-staffed. That's what I was told.
When you say that's what you were told, did you discuss the potential of having to serve in this case since you filled out your questionnaire?
Yes.
And could you be a little more specific about your, you don't need to name it, but the occupation and what your employer may have related to you?
The occupation is with alarm codes. I was on the central station, so I just answer a lot of alarms for places all over the country. And what I was told was that they're extremely short-staffed. If I was gone for 10 weeks, they would probably have to let me go because they'd have to have somebody else take my place.
All right, with that particular concern raised, I am going to pass over for additional questioning at this time from both the state and then the defense. Does the state have any further questions for this juror number 67 in regards to the stated hardship?
We don't have any further questions, Your Honor. We would have no objection to this juror being excused based on the hardship expressed today.
All right, from the defense then, Mr. Pryor.
Judge, there'd be no objection to having this juror excused.
All right, well, juror 67, if you are facing loss of employment over this, the court would find that would qualify as an undue hardship that would prevent your service in this case, given the length of the trial. So the court thanks you for your service for coming in this morning. I'll allow you to be excused. Please drop off your copy of your questionnaire with the bailiff on your way. I believe juror 348 raised their card as well. Juror 348, you've heard the questioning about the trial length. What's the issue you would have in relation to that? Let's get the mic to you.
We have two family events that will transpire here during this time or directly after, one of which is my daughter's graduation from college. I did note these on the questionnaire in the circumstances with her graduation. That would be at the beginning of May. We were not able to have any kind of graduation celebration for her from high school, as that was 2020. So we were all looking forward to that as something we would all participate in as well. My mother passed away in February, and I am responsible as executor for her estate to prepare documents. I'm working with lawyers on the East Coast, which makes it a challenge as far as the time difference is concerned, as well as planning for her service, which will take place in June. Again, that is taking place on the East Coast. And I am responsible for planning that event as well. So those are the two circumstances as I noted on the questionnaire.
And could you specify again, is it the first weekend of May that the graduation would take place? Is that on weekdays or is that going to be on the weekend?
The graduation takes place on a Friday. That would also involve transportation down on either Wednesday or Thursday if it's out of state.
All right, council, I'm gonna again inquire of you. I know we're skipping ahead. You'll get your own individual board dire, but on the narrow issue of a hardship expressed with juror 348, does the state have any additional inquiry?
No, Your Honor, we would have no objection to this juror being excused. I do know on the questionnaire, she had indicated the graduation would be the first weekend of May, including Thursday to Sunday.
All right, any board dire from the defense on the issue?
No, Judge, I was also aware that she had the obligations that required her to travel out of town.
Okay, well, between the combination of that planned graduation and your services as executor of an estate and that both being expressed in your sworn questionnaire, the court does find there's a rationale here for dismissal based on a hardship given the length of the trial and the timing. So juror 348, you can be excused with the thanks of the court. Thank you for providing your service here up to this point, and please drop the questionnaire off on your way out with the bailiff. Were there any other jurors that had an expressed concern over a hardship at this point? Okay, juror number 321.
I have not looked into the policy as far as the amount of time, but it would be a financial hardship if that length amount of time without me working.
All right, I'm going to note juror 321 that you've expressed a concern over hardship. I'll pass on that at this time and allow for the attorneys to conduct some individual voir dire further on the topic if they so wish. So we'll come back to that. Anyone else have a concern? Juror number 296.
Good morning, Your Honor. I am currently in school on Mondays and Wednesdays, and CWI would conflict for the next 5 weeks. I put on my questionnaire that it's possible that I could take online courses or switch to an online course, but not entirely sure of that policy.
Okay, I will note your concern as well. I'm going to allow for some additional voir dire from the parties before we make a determination on that. Anyone else have a stated concern for the hardship? Okay, thank you. Let me next discuss any previous knowledge you may have of this case. As I mentioned before, if you do know something specific that you've heard in the media or otherwise, please refrain from stating specific facts about that, but we do want to go into that issue. So first, let me see, I guess, by raise of your cards, other than what you were told when you came in to fill out that questionnaire and further advice today, do you know anything about this case, either through your own personal knowledge or by discussions with anyone else or from media information you've received? Is there anyone that knows about the case? Okay, if you'll hold those up for a moment, we'll know. So we've got juror 321. The question generally is just, do you know something about this case other than what you've learned by coming in for the questionnaire last week or today? All right, so on the back row, 321, 296, 219, 249, 146, 121. On the front row, we've got jurors 56, 48, 41, 31, and 27. So the majority of the group here which is why I give that instruction. What we don't want to do is start seeing what everyone knows about the case. We'll talk to you individually about that. Let me ask some specific questions for you then without getting into those details, but then is there anyone here that believes they already have a state of mind with regard to the charges or some knowledge you already have about the case that would prevent you from being impartial in this case? In other words, has anyone, you think, already drawn some opinion that maybe the defendant is guilty just based on what you know or what the charges are? All right, we've got a juror number 121 who brought that concern up. In order to further get into that discussion, we'll talk to you individually so we can delve into that. Anyone else that thinks they've already perhaps made their mind up in some way about guilt or innocence in this case? All right, we've also got juror number 48. We will discuss that with you individually as well. For those of you that do know something about the case, the next question is, do you feel you could eliminate or disregard what you've heard or read pertaining to the case and render an impartial verdict based solely on the evidence you hear in court today? All right, the remaining jurors then indicate they would be able to do that, and I'll allow the attorneys to follow up with voir dire on that subject.
Judge, could we approach all of those?
Certainly.
Pryor got nervous. I'm telling y'all, those last couple of questions, they wiped that whole jury pool out right there. Okay, Pryor was just like, you know what I'm saying? He's over there talking about, look, Judge, maybe we should ask that question first. Then I think they should ask that first, then do the schedules, because that's going to take everybody out. I mean, seriously. Oh, that's my chair. My chair's squeaking. I thought it was Roscoe. So here's my thing. Pardon me. Again, out in that area, I mean, it's, and like we've been talking here, yeah, it would be very hard for any of us, especially people that have followed this. So many people watch true crime stuff these days that to me it would be very difficult. So then you have to truly get into, can you set aside any preconceived biases? And like for me, like with this case, I'm like, there's no way. There's no way. But if it was like a case that I hadn't heard of, then obviously it's like, well, yeah, I mean, let me see everything. You know what I'm saying? If it's something where you had heard of it, but you were like, I don't know, this person might, be not guilty or whatever. Okay, great. Something like this where it's like, I mean, come on, like, what's he gonna say? You know what I mean? Like, look at what happened to Lori. I mean, the kids were in his backyard, for God's sakes. I mean, all this stuff, right? So it'd be, to me, this is gonna be a very hard case to see. But like once I went through those things, and to me, what I've heard so far is the things that people are presenting with their schedule. It's like, okay, cool. But I guess they do look at it like, okay, what's your schedule like? These are the people that could actually show up for the trial, right? So now let's get into, who's heard of what or whatever. This is going to be where Pryor and them drag this out. But this is what really makes the case. You know what I'm saying? I mean, they're seating the jury, like, to decide his fate. And again, pardon me. Yeah, can you imagine if Chad took the stand? I don't think he will, but my God, can you imagine? AI jury. They're gonna have to get an AI jury. They are literally gonna have to get an AI jury. Oh, Roscoe says he's ready to be held. Come on. See, man. There's nothing really going on up here, buddy. It's just kind of boring up here. See, where's the sofa? See, for this, I really should get, if I set this situation up over at the sofa, the real sofa, but I'd fall asleep on y'all. Within moments, I'd be like, I'm not gonna lie, I couldn't make it. I could not make it. That's what I was talking earlier, where I was like, I watch these trials and I know it's serious, but at this point, they have the defendants. Let me look at Chad. He's sat in trial and in jail for years. Obviously, your adrenaline's going, all that kind of stuff. But those chairs sitting there like that, I'm like, there's no way I would fall out immediately within a couple hours. I would just be over there. They'd be like, really? I could be completely innocent of the charges. And I'd be like, I'm sorry. There's no way. So, oh, here we go. Yeah, Connie says
All right.
Chad looked like he was in his portal.
We're back on the record
Kept
now.
on muting.
continuing For this group. Next issue the court's going to talk about with the prospective jurors is the subject matter of this case. Court has read to you a summary of the charges. Those include charges involving murder, conspiracy, and insurance fraud. Is there anything in particular about those charges for any one of you that would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and to render a fair and impartial verdict? So the question is, would that make it impossible or difficult? If that is the way you feel, please raise your red card. Okay, none of the jurors responded affirmatively to that. I next have some questions that may seem obvious, but they're required by our statutes for me to go through as well. Let's talk about relation or acquaintance to the defendant. Are any of you related by blood or marriage to the defendant, Mr. Daybell? If you know him or her from any business or social relationship? If you do, please raise your red card. All right, no one answered affirmatively to that. Let's talk about the relationships you may have with any alleged victim, defendant, or attorneys here. Does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you or any of the attorneys involved in this case? So raise your red card if one of these lawyers is your landlord, for example. All right, no one has responded affirmatively to that. Are any of you involved in any kind of a legal proceeding, including a civil action against the defendant? No affirmative response. Have any of you ever brought any kind of a criminal complaint against the defendant or been accused of a crime by any of these prosecutors now present today? There's no affirmative response to that. Do any of you have any kind of an attorney-client relationship with any of the attorneys here or with Mr. Pryor or his law firm? Okay, no one responded to that. Do any of you have any kind of a relationship by blood or marriage to any of the lawyers in this case, or do you know the lawyers from any other professional, business, or social relationship? All right, no one indicated they know the attorneys or have any kind of relationship that would be prohibited. This next question is a general question, but let me ask, have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? Okay, no one indicated they've got an opinion. Do any of you have any bias or prejudice either for or against the defendant, in this case, Mr. Daybell? No one responded to that. Are there any of you who would be unwilling to follow the court's instructions to you, the jury, as to the law that you must apply in determining this case? No one responded to that. Now, in this case, we will be asking you further questions individually about the section of the questionnaire you filled out relating to the death penalty. So I understand that may come up here. We will talk about that individually, but notwithstanding, I'll ask the group here, do any of you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict in this case? Okay, no one responded affirmatively to that. Are there any of you that if selected as a juror in this case would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law as instructed by the court? All right, no one indicates they would be unwilling or unable to render a fair and impartial verdict. Kind of a catch-all question here. Do any of you have any other reason why you cannot give this case your full undivided attention and render a fair and impartial verdict? Very well, no one responded to that. That concludes the court section of group voir dire for this group. At this time, then, I'll permit the state to conduct its voir dire of the group. After that, the defense. Will that be you, Ms. White?
Your Honor, Mr. Wood will be starting the voir dire process.
All right, Mr. Wood, if you'd like to commence with the state's voir dire, you may do that at this time.
Thank you. And is it all right if I do so from the podium?
It is.
Thank you. Ladies and gentlemen, again, my name is Rob Wood. I represent the people of Madison County, Idaho. And just as a reminder, if I ask you anything today that makes you uncomfortable and you would rather answer it privately, just let us know. We want you to be comfortable, and we need you to give full answers and fully truthful answers. The defendant is entitled to a fair trial, and we only get there. And the state's entitled to a fair trial. We only get there if you're being fully honest with us. And so I'm going to start by asking juror number 321. What do you think of when I say the phrase brutal honesty?
I believe that just means not mincing your words, just no matter what, just telling the 100% complete truth about how wrong it's.
All right. Does anyone else have a different definition of brutal honesty? But not mincing your words. Can everybody agree that telling the full truth, not mincing your words, is a good definition? Okay, and we need you today to be brutally honest. There's just a quick analogy I like to use. Who, by raise of hand, who here has flown on an airplane? Everybody's flown on an airplane, right? And you get on the airplane and that pilot, you get strapped in, they give you the safety warning, and the pilot tells you when he's going to land that plane approximately and where he's going to do it. How many of you would feel comfortable if the pilot said, I might be able to land this plane? You're all smiling. Would anybody feel comfortable with that pilot? Okay, so ladies and gentlemen, today we need you to land the plane. And what we mean by that is not a specific destination, but that you're completely honest. It's that important. The court asked you about following the law. Does anybody here like and enjoy every rule, law, and regulation you live under? Nobody does, right? Does anybody, just by a raise of hand, can you, not that you need to tell us what it is, but think of a law or a rule that you think is unfair? Everybody, you can think of a law or rule that's unfair, great. Multiple people feel that way. In this courtroom, the court will give you the law that applies in this case. And you may like that, you may not like that law. But for fairness to this defendant and for fairness to the people of Idaho, we all have to agree, follow that law. So even considering that maybe you won't like the law that you get, maybe it doesn't go with your gut. Can this defendant and can the state all rely on you to follow the law as it's given by this court? If you agree, yes, can you hold up your red card? This is important. 121, I saw a little bit of hesitation. Was that accurate or was that just me? There is some hesitation. Tell us about your hesitation. And thank you for your honesty.
Yeah, I mean, I don't know if you were gonna get into this later, but my hesitation is with the death penalty issue. That's where I hesitate.
Okay, so, and we will talk about that, but thank you for bringing it up and thank you for being honest. I'm gonna just shift gears really quickly. Does anybody here believe everything they hear on the internet or see on the internet? I'm the only one. So does anybody here believe everything they hear on the news? Everybody understand that the news is not always accurate. I'm not saying that to offend any reporters who might be here, but we all understand that facts change sometimes, right? And you might hear a story one day, and some of those facts are different the next day. This case has had a massive amount of media attention. And the judge asked you this, but we just want to check again. Is there anyone here who has any concerns of what they've heard before? And we don't want to go into a lot of detail now, we'll get into it later, but what they've heard before is going to cause them to not be able to give this defendant a fair trial. Okay. Some of you talked about hardship, and we're just going to go over that really quick. Juror 249. If I recall, and if I say it incorrectly, just feel free to correct me. You get about 2 weeks of paid juror time. Is that accurate? Okay. Are you, if it's all right, if I ask you the sole provider in your home?
Yes.
Okay. And is it fair to say that you and your family rely on your income?
Yes.
Okay. And have you, I forgot, did you speak with your employer about this specific issue?
I have. I just let my supervisor know that. This
Oh.
could potentially be a long-term commitment. And then when I was thinking about it a little further, I thought I better, I'm into what our current policy says, stated. And that's when I found out that they only account for 80 hours for it. So,
Okay.
and after that, you're basically on your own. Either you have to use your vacation, which nobody has 10 weeks of vacation, right? Or unpaid.
Would you see that as an undue hardship for you that would create difficulty for your family?
Yes.
Your Honor, the state would move to excuse juror 249 for hardship.
I'd like to hear a response from the defense, and if you have any additional board items prior, you can do that as well.
Nothing additional, Judge, you will stipulate.
All right, based on the comments made by juror 249 as it relates to an employment hardship and financial with the length of this trial, the court will agree that the juror will be stricken for cause based on a hardship that includes his service. So thank you for appearing today and for performing your service as a juror. You can be excused, and please drop your questionnaire with the bailiff.
Juror 296, you had spoken about potential hardship, and I noted in your questionnaire, you said you had school Mondays and Wednesdays, but could do online classes. And you mentioned that, but I guess I'm not quite sure where it stands. Are you able to do online classes to finish that?
I'm not entirely sure, but I know they offer online classes for the classes that I'm currently in. So I'm assuming they could probably move me to the online classes. The only issue that I would have is the testing that I have to take either after hours or via online.
Okay.
The lecture part is in class. Like I can do or the lecturing I can do online.
All right, and it's not school 5 days a week, just the 2 days a week?
Just two.
You mind if I ask how many classes?
Two.
Two.
Biology and class.
All right. And so if, with the court's schedule of getting out at 3:30, do you think that would be something you could make work?
Yes.
And so would it be an undue hardship to be on this jury with your school?
Not that I'm aware.
Okay, thank you. Juror 321. You had mentioned a hardship. Could you? And I apologize, I kind of can't remember exactly what you said a few minutes ago. Can you tell us what that was?
Yeah, I'm just unsure as far as, because I've not spoken with the employer about the length of this trial, I may go. I just know that it would be unpaid time off.
Okay. Are you a sole provider in your home?
Yes,
But so you haven't spoken with them yet. So are you sure that it would be unpaid time off, or do they have some type of juror policy where they pay you while you serve on the jury?
honestly, I'm not aware. They might possibly have a policy, I just don't know about it.
Do you think that's information you could find out in the next couple of days and notify the court if there was a change?
Absolutely.
Okay. Thank you. I also did note in your, I believe it was in your questionnaire that you wanted to see some college games of one of your children. Is that you? Am I confused? Okay. And where are those games?
They're in Oregon City, Oregon.
Okay. And is baseball?
Yes,
Okay. What year is your son?
he's a sophomore.
Okay. And I'm not trying to be insensitive. Being a juror is hard for everyone and inconvenient, but if you weren't able to see some of those games, would you be able to see them next year?
Yes,
And so would it be an undue hardship to miss some of those games?
No.
Thank you. The court spoke with you briefly about the nature of this case. This is a case about murder and conspiracy to commit murder and insurance fraud. Two of the alleged victims in this case are underage children, a 7-year-old and a 16-year-old. And the other alleged victim is a mother. There will be some autopsy photographs in this case, and they are hard to look at. There's no way around that. But does anybody here think that seeing those would automatically sway them one way or the other, or that they'd be able to objectively weigh those, still weigh that evidence against all the other evidence? I'm sorry, did you raise your hand? No. Okay. So this is important. If you guys can raise your cards, if your answer is yes, would you be able to still weigh all the evidence properly, even if it's difficult to look at those pictures? So juror 48. Oh, okay. Thinking. Or what are you thinking? Do you think you'll be able to do that?
I just want to make sure I understand the question. If I could see the photos and not be swayed one way or another, continue to weigh the totality of the evidence. That's
Yes.
what I'm-
Yeah. And then I just have a couple more questions, Your Honor. I know Ms. Blake has a couple of questions. Juror 294. In your questionnaire, you said that you marked a box saying that you think a person, excuse me, who doesn't testify is probably guilty.
Yes.
So do you understand that the state has the burden of proof?
I do. I was just being honest, like just from my gut. Yes.
Yeah, and we want you to be honest.
Yeah.
And we appreciate that. There's nothing wrong with that. So you will get an instruction, and you'll be told by this court that the defendant doesn't have to say anything. The defendant doesn't have to prove anything. It's 100% on the state. And so is that feeling you have, is that something you could follow the rule and the law the court gives you and set that feeling aside and not hold it against the defendant if he doesn't?
Yes.
I'll just correct the record there for a moment to that's juror 394.
Oh, I said 294. I
Yes,
apologize.
that's fine.
394, thank you.
Can I take this moment to mention hardship?
Please do,
Okay.
yeah.
It's not necessarily hardship. There's a family vacation, family reunion, scheduled for week 10, June 6th through 10th, but travel would be needed on either side to Arkansas. It's not a hardship, but I thought I'd just mention that. I'm not losing work. I didn't anticipate, checking on my jury duty leave for work, so that's an open question in my mind as to if I can take the whole time, that's acceptable, or if it actually is a restricted amount of time like other people in this profession of like today.
Okay, and if that does create a hardship, will you let the court know?
Yes.
Juror 41. You had marked something similar on your questionnaire that you want the defendant to testify. And I'm just gonna ask the same thing. Do you understand that only the state has the burden of proof in this case? And that it's the state's job to prove something. The defendant doesn't have to prove anything. Okay. And so even though you have that feeling, is that something you can set aside and follow the law and the rules that the court gives you and not hold that against the defendant? Okay. Your Honor, at this time, I know Ms. Blake has a few questions, so I turn this time over to her.
Very well.
Good morning, ladies and gentlemen. Thanks for being back with us today. I know you were all here last week, and this is a bit of a process, so we appreciate you hanging in there with us. And I will try to be fairly brief because I know you've already had a lot of questions today. So the judge has already started to give you some instructions, and as you go through this process, he will give you more instructions. So I'd like to talk to you a little bit about, I have a son, and usually in the mornings, if I ask him what he wants to eat, he tells me cheesy eggs. And there's a very specific recipe that I have to use. So it's the eggs and the milk, and he likes quite a bit of cheese, and then some salt and pepper. But if I try to modify that recipe, he doesn't always like it. So I don't know, have any of you had that experience where whether you're cooking or doing something else for a kid or a family member, they like things just done a certain way? Would all of you agree? And turning to juror 27, can you give me an example of something like that?
Yes, I have 4 kids and they are very opinionated on how I cook and prepare their toast and their sandwiches and how I cut it. And so, yeah,
You can relate.
really.
And so even if you think there's a better way to do it, do you sometimes just follow what your kids are asking for?
Well, in relation to food, yes. If it's something that's going to injure them, no.
Yes, I'll keep it with the food example. So if it's food, they want the crust cut off, something like that, you'll do it because that's what they're asking you to do.
Yes, I mean, unless there's a nutritional opinion I have, but if it's something simple, sure.
And in the back there, juror 186, I think I also saw you nod. Can you give us an example of something like that?
Same thing as you guys. I have 4 kids as well, and they like their food a certain way, especially when they're little. Anything to get them to eat.
And if you know a better way to do it, or maybe you would add something because it gives it better flavor, do you sometimes follow what your kids want?
I try to give them, sneak something in there that maybe I think will taste better. Try to change their mind. Food. They're little.
And so with this court, because unlike a kid, we're going to get instructions from the judge. And if the judge gives you instructions, they may say, these are the specific elements of a crime. And sometimes it's easy to look at that and say, well, that doesn't make a lot of sense. Or if you added this, it would make it a little bit better. Would everyone here agree that regardless of what you may think with the rule and instruction given by the judge, that you could absolutely follow what he outlines? Would everyone agree that you would hold the state to the burden of the specific elements outlined by the judge? So even if you might say, this would make it a little more nutritional this time, or hey, I might sneak a new flavor in, everyone could refrain from doing that if it was an instruction from the court. Does anyone have concerns with doing that? Thank you. And as I talk about, the judge is going to give you instructions, and some of those instructions are going to be regarding the burden of proof being on the state, and then they will also be the elements. With regard to charges of conspiracy and first-degree murder and conspiracy to commit first-degree murder, one of the elements is not going to be that the state has to prove the cause of death, meaning the state is not going to be required to prove exactly what caused the death of a person. Our element would be to prove that it was a homicide. Does anyone have concerns if you were to be presented evidence that someone was killed, but the state did not provide a specific cause? No concerns. So if the state put on evidence that it was a homicide, but not the exact cause of that homicide, that wouldn't cause anyone concern. Because again, you'll have instructions from the judge. 394, I see your card up. If you're given an instruction though, that says that that's not a requirement, would you be able to follow that instruction, or would it be difficult for you?
I think it would be difficult, just based on the question.
So in this case, you are going to hear from quite a few witnesses. And some of the witnesses may have different religious views than you have. Does anyone have concerns that it would be difficult for you to listen to or give proper weight to someone's testimony based on them holding different religious views? Would anyone have problems if someone held different views in general, again, just with being able to weigh their testimony? And you're also going to be given some instructions, actually back that up. So if you were sitting in here today and the window wasn't there, or they put the blinds down and you couldn't see outside, but when you came inside, everything was dry, everything was clear. And then as you enter the building, you see the sky starting to get a little bit dark. It's starting to turn gray. You come in here, they close the blinds, you can't see outside, and you go outside and there's water on your car, and there's water on the pavement, water on the grass, everything's wet. What would you be able to determine what had happened? I see some nods. Juror 296, what would you determine had happened? And would you determine that even if it had quit raining by the time you got outside? So there would be enough there without you actually personally, physically observing the rain. And 321, I saw you nodding as well. Similar? And so would everyone agree, you may hear the term circumstantial evidence. Even if you don't see something happen, there could still be other evidence to support that. And would everyone be willing to weigh that evidence? Because again, as jurors, part of your job is going to be to weigh all the evidence and give it the weight you feel that it's due as you're listening to all the testimony, the evidence come in. Anyone have concerns about their ability to do that? I can have just a moment. The state has no additional questions, Your Honor.
All right, that will conclude the state's portion of voir dire for the group. Mr. Pryor, you may do so on behalf of your client now.
Morning. My name is John Pryor, and I represent Mr. Daybell. This question, folks. Before we start, I really want to talk to you about the fact that there's no wrong answer. What's more important than anything else is that you tell the truth.
Mr. Pryor, apologies. Could you into the microphone a little more? We're barely getting your signal. Thank
And I'll
you.
turn it on. Does that help too?
That helps a lot.
At my age, Judge, technology is a challenging job, and I apologize. Can all of you folks hear me now? So I'll reiterate, the fact is that as jurors, your job is to judge the evidence. Your job is to make a determination, apply the facts to what the judge gives you as the law. But before we get there, what we have to do is go through this painstaking process of talking to you folks about some personal things and some private things, some of your thoughts and processes. And part of that is to, before we get there, is we really want to talk about just being honest and truthful about your position. There is no wrong position. If there are some people here who say Mr. Daybell is absolutely innocent, that's your position. If people feel that Mr. Daybell is absolutely guilty, that's your position. If you really haven't made up your mind, that's your position. But it's your position and it's your own individual position. And what's important is that you apply the facts not as you see the group and go along with the group, but that you basically tell the truth and you speak your mind. This is your opportunity to say how you feel and to be honest about how you feel. Is there anybody who really doesn't understand that? Perfect. I must have been pretty clear and you can hear me now. That's wonderful. Before we get started, this is an unusual question I ask. And I ask this because I've had the opportunity to sit in that box a handful of times and over the number of years that I've been an adult. And this happened to me many, many years ago. I was 21 years old and in college, and the lawyer was involved in a criminal case. And he asked an unusual question. As soon as he got up there, he asked an unusual question. He said, is there anybody who just doesn't want to be here today? And a number of us were hedging and moving and everything else. And I thought, yeah, I don't want to be here. I don't really want to. Well, why don't you want to be here? Because I just don't want to be here. I just have so many other things in my life and I have so many other distractions and I have so many other processes. And I was a college student, naive and wide-eyed, and I said, I understand the obligation to be a juror. I understand that it's something that we have to do as our civic duty, but I just don't feel like I can give the attention to this thing that I really think it deserves. And surprisingly enough, the lawyer said, well, thank you for being so brutally honest, and the judge let me go on my way. Now, I don't want to give all of you an opportunity to raise your hand when I ask this question, and please don't, if you really think you can give the attention. But is there any of you folks who quite honestly, you just don't want to be here today? And please be truthful with that question. You're all very excited to be here. And you're all very anxious to get involved in this. Okay, number 394, go ahead, sir.
Yeah, I definitely want to do my civic duty. I feel like that's the proper thing to do, and I'm thankful for everything that you guys do. I'm a year and a half, about a year and a half into a new job, building a team. We have one person, I'm a team lead, I've got one person under me, we're trying to hire another person. So I question whether my success in my job will be as good as it could be if I was there versus being out for potentially 10 months. And of course, I don't want to think deeply about a murder case, just the content. But again, I want to do my civic duty, so that's kind of where my.
And I appreciate that. Your job's important. You're a data engineer, if I remember right. I'm going off of memory.
Yes,
My memory serves me that that's what you do as a data engineer. Is that right?
I am a data engineer.
I said data, it's data.
Yeah.
You know, back and forth.
Yeah, my wife's a part-time biller about 10 hours a week, so I'm the primary.
Do you have children?
Yes, we have 3.
I remember that as well. I just wanted you to tell me that. Okay. And do you really think this could potentially affect your occupation?
I don't know. I need to talk to my manager today and see realistically how this would impact either my future growth or the paid time off policy for jury duty.
Well, the one thing that caught my attention was that as a data engineer and having been married, and she's going to kill me for announcing this to the world, I guess, my ex-wife was an engineer. And it was, everybody's smiling about that. I understand that when you're working on projects, that a lot of time those projects are particular to the individual engineer. Is that your position as well?
Yeah, we basically serve all areas of the business, whether it's product or finance or customer success. So they're long, they can be very short requests, but usually they run multiple weeks.
Okay, okay. Is there anybody else who would like to, provide me information about whether they just don't want to be here? And frankly, folks, there is no wrong answer. I can assure you that the story I told you about speaking up and saying I didn't want to be there, absolutely true. And then it was just one of these situations where I just felt like I couldn't provide the necessary attention. And that was going to be a 2 or 3 day trial. What we're dealing with in this case, folks, is a 10-week trial. And it's going to take a lot of time and it's going to take a lot of effort. And I want to make sure that all of you are going to be able to do that. That's a significant request from all of you. And all of us, the 4 prosecuting attorneys, the judge and myself, Mr. Daybell, we're asking you to put that kind of a commitment into this. It's 10 weeks. It's 2.5 months of your life that we're going to be asking you to put forth. Juror number 27, you're shaking your head. Do you have any concerns or questions about that? Or thoughts, please?
No. I'm shaking my head in agreement that it is a big commitment, but feel if this is what you feel I should do, then that's just my duty to it.
And I guess I'd be clear on that. I welcome everybody's thoughts on that. And I don't want anyone to think that, well, you're doing this because it's what you feel I want you to do. In your own mind, and I can't evaluate what each of your life situations are. I'm given a very small description of facts, the questionnaire that was filled out, and the difficult situations that I have to determine. And sort of the 4 prosecuting attorneys who are working on this case, we have to determine with that small window of information what kind of impact this is going to have on you. That's very important. I do spend time on this. I spend a lot of time on this. And I do that because the consequences are significant here. You've all read or heard the allegations against Mr. Daybell. And I just want to make sure that all of you are going to be able to put that time commitment in and spend the time to work on this significant project. And much like our friend 394, it's a significant project. So again, is there anybody who's having any hesitation? Please speak up now, because the time to change your mind will become difficult. So I ask again, is there anyone who's having any concerns or hesitation? 121, please tell me what your thoughts are.
I mean, I feel kind of similar to what he said, where like I do recognize it's, my duty, and but I just think like I've just been thinking a lot about just how a lot of the troubling aspects of it, and that's a reason why honestly I was like didn't want to be here today. would be the trouble in that space.
And is it your position you would just rather not be part of this? And please be honest.
Yeah.
Okay. Do you think that your views and your thoughts on that would create some sort of concern in how you look at the evidence?
Yeah.
Would you be more inclined to rush through this because you want to get this done?
Yeah.
Would you be able to take the time to look at the facts and look at them, in an impartial manner?
Yeah.
Okay, all right, thank you. And I appreciate your honesty, I really do. Please, and I'm gonna forget, juror number 121, I think. No, 146, I'm sorry.
I was just gonna say,
Would you, officer, would you please do it? I have a loud voice, but not everybody's gifted with such a objective voice as I am.
I hate my voice on the microphone. I think every one of us probably would be lying if we said we were like so excited to be here and wanted to. But I feel like it's just jumping out of my chest. Like if any of us are supposed to be here, we will be here.
Okay.
I'm not particularly excited to be here. I have 5 little kids, but it is what it is. And if we're supposed to be here, we'll get picked and chosen. And
Well,
I don't know why, but that's just how I feel about it.
and that's one of the things that I looked at when I saw your profile. You had 5 children,
We have 5 kids and I run a daycare.
run a daycare center. And then I'm gonna use my cheat sheet a little bit, but in addition to that, I guess I didn't have to just pop in my head for some reason, but your husband is involved in landscaping.
Yep, we have a landscaping business too.
So do you help in that landscaping business?
No,
No.
I mean, like, paying invoices and things like that I do, but not.
So you do paperwork in your free
I'm
time,
the free
when you're,
secretary.
when you raise the, and I'll get to you in a minute, I just saw the reaction. Juror number 186, I just saw the reaction, I'll get to you. In your free time, when you're not dealing with your 5 kids and gathering them up and taking those family responsibilities, you're then taking on the obligation of running a daycare. How many kids do you have in that daycare?
3 to 4.
Okay. And then, like you said, in your free time, when you're done taking care of the kids and taking care of the daycare, you then do the paperwork.
Yeah, when it's needed.
It almost sounds like this would be a vacation.
If I'm being totally honest, when the judge said at the beginning you could be sequestered, I was like, oh, it's gonna be a spa for me. I think it would be.
Well, I think it was your questionnaire. I read that you made some comment in the questionnaire saying, LOL or something like that. That was yours.
Probably being a smart ass, but a sequestered would not be like the worst thing for me.
Okay. And thank you for your honesty. And then juror number 186, you smiled and you had some thoughts. Please talk to me
Oh, I was just smiling at her comment of being the free secretary.
about it. Okay, and tell me about that, how that applies to you.
I just thought it was funny that the way she worded it
Oh,
had
I-
nothing to do with me.
Okay, okay. Okay, is there anybody else, and I know I've spent a lot of time on this, and it is important, and the idea is to get you folks to be, I understand, at least the camera's on me right now, from what I understand. And it's not on you, so you have this wonderful opportunity to speak your mind and tell me what your thoughts are on this, whether or not any of you, for the last time, do you really have any reservations or anything you would like to comment about participating in this process? Anyone? No one? Okay, thank you. I'm going to move on to a little bit of a different subject. And one of the things I need to talk to you folks about is that Mr. Daybell's here today because he's pled not guilty to the charges. And I'm going to ask you questions that may concern whether he's guilty or not. And I don't want you to read from my questions that I believe Mr. Daybell's guilty or anybody else believes Mr. Daybell's guilty. The fact is, we still have to delve into these questions and talk about these things because it's important that we try to get in this very little time that we're going to spend together, get an idea of what your thoughts are, what you folks are thinking, how do you feel about a variety of things. So please don't read into my questions or assume I'm asking you something because I believe one way or the other. Once again, all I'm trying to do is to just get an idea of the person you are. Right now, I'm speaking and it's being broadcast everywhere and people are getting an impression. I don't know if I want to read some of the impressions they're going to talk about me or say about me, but they're getting an impression. And by the same token, I'm gonna ask you questions to also get an impression, get an idea what you think about, and that's what's important. It's important that I do that because it's the way we are able to determine whether we think you're a good fit, whether the prosecutor thinks you're a good fit, and that's part of the overall process of doing this jury voir dire. Juror number 56, you were nodding your head. Is there something you would like to offer in regards to that?
No, just agree
You're
with the
agreeing.
process.
Well, thank you. I appreciate that. I'm going to go into a couple of different areas, and please don't, again, don't read into this one way or the other. Just again, I think what we're trying to do is be able to build a relationship between myself and all of you folks, so we can be open and honest and free about what our thoughts are without worrying about what people might think. Because quite frankly, I don't care what any of these people think. I could care less, and that may hurt some of their feelings. But I do want to know what you folks think. It's important, and the state wants to know what you folks think, and it's important because all of us agree that in the end, the state's entitled to a fair and unbiased jury. Would everybody agree with that? Could raise your things, no, not your hands, just your numbers. I'm sorry, folks. I just want to thank you. Thank you. And would all of you agree that Mr. Daybell is entitled to a fair, unbiased jury? Okay, thank you. And on that note, I'd like to start out by asking you folks, is there anybody right now who thinks that Mr. Daybell is guilty or is probably guilty? Okay. Okay. And that's juror number 48, was it not? Now, juror number 48, is that going to impact your ability to make a determination as to, in the end, whether or not Mr. Daybell is guilty, going into this process with the idea that you believe or possibly believe that Mr. Daybell is guilty? No. Okay. You're going to be able to be unbiased.
Yes.
Okay. And let's talk about that because that leads into the next area that I'd like to talk to you folks about bias. Is there anybody who doesn't understand what the word bias means? No hands. Okay. What about the words impartial? Does everybody know what the words impartial means? Yes? No?
Kinda.
Okay. Okay. Juror number 41. When you say kind of, what is your 30? I'm sorry, you're right. 11, 21, 31. 41's next.
No, I'm not sure what impartial is. The first one you said was
Bias.
bias.
Okay.
So I'm trying to think in my mind the difference between the two.
Okay.
So bias.
What are your thoughts on that? What do you think impartial is?
Depending on what I see, if I trust in that,
Okay.
or I don't trust in what I see.
Okay.
Is that kind of what I'm
Okay.
looking for?
All right. Okay. Okay. Juror number 219. Thank you. What are your thoughts on when you hear the words impartial?
That I would be neutral until basically there's sufficient information to make up my mind one way or the other.
Okay. Okay, is there anybody who disagrees with that? You must be a teacher or something, because that's a great explanation.
No, sir.
Okay. Is there anybody who disagrees with that you must remain neutral? Does everybody agree with that? You must remain neutral? Okay, thank you. So we're going to go back to this issue of bias and influence. And you're going to hear from a lot of witnesses. does everybody agree that there are witnesses that can be influenced and sort of coerced into saying things that are not necessarily true or false? Everybody, would you raise your hands to see if that's something everybody agrees with, or if you don't agree with it? Or your cards, either way. I didn't see at the very back there. Looks like 296. Okay, I'm sorry, I missed it. I'm sorry. Just being influenced or coerced, do you think that just applies to citizens? Anybody think that it just applies to citizens? Raise your hand if you think it just applies to citizens. Okay. What about law enforcement? Anybody agrees that law enforcement could be swayed? Maybe they could be influenced to go and testify a certain way to support one side or the other? Anyone? No one thinks that's possible?
Can you restate it? I'd like to.
Just law enforcement. Do you think the issue of being biased or being influenced, do you think that just applies to ordinary citizens? Does anybody believe that it could also apply to people who are in law enforcement? Now, I don't want to pick you out, and please forgive me, number 27, but my recollection when I read the profiles, and this was last week, is that your father's a police officer. Retired police officer, that's right. Okay. Is that concept something that, just the fact that I bring it up, is that somehow offending you or causing you concern that I'm bringing a statement up like that?
No, I absolutely believe there are good cops and bad cops.
Okay. And in that instance, when we're talking about officers, that police officers are no different than every ordinary citizens, right?
Correct.
And they're susceptible to the same influences and the same manipulations that other people are susceptible to, right?
Yes, correct.
And when you're talking about a criminal case, and you're talking about a law enforcement officer, what do you see as the role in that case?
The same as all of us, seeking the truth and believing the truth without a bias.
Okay, what if they have an agenda in advance of the investigation of cases? Would that cause you concern?
If the police officer has an agenda, yes, that would have a bias then.
Okay. And as far as a role in a case, would you agree with me that a police officer's role in a case is to investigate the facts and report the facts?
Absolutely.
Is there anybody who disagrees with that? Nobody disagrees with that? What about a police officer or an agency that decides to aid in supporting one side or the other and pushing their own agenda? Is that problematic for anybody? Raise your hand if you think that's problematic. Or raise your cards. I'm sorry, Judge, I guess brought cards. So nobody disagrees with that. So when you hear evidence of that, is there anybody who causes pause for concern as to how they evaluate the bias of that particular police officer? In other words, if you hear that a police officer has an agenda, that he's pursuing a situation where they're trying to develop the fact that someone is guilty rather than investigating the case. In other words, they found their target. Okay, and I don't want to get into.
Do we approach?
Yes.
Y'all, oh my God. Oh my God, y'all. I will say this. I mean, Pryor is doing a good job, like at what he's doing. I mean, he's getting in there and rooting them out and really weeding them out. Because another thing too that I think he's doing is because if you followed him before and watch him, he gets under people's skin. It's part of his thing. So it's almost like if he can root the ones out that are going to be like going back and forth with that now, better to do that now. You know what I'm saying? because like this woman who's talking, who's trying to go toe to toe, head to head with him, it's like just send her right immediately. Tell her to grab her purse and go. Okay, right now we need her gone. These two, no. I mean, my goodness. So, Julie, how long have they set aside for jury selection? At this point, I'm thinking 10 weeks. I'm just like, oh my God. I don't know, honestly, but I mean, just move it along prior. Okay, here we go. I'm muting it again.
So I've been talking to you folks a little bit about bias.
Mr. Pryor, I apologize for the interruption. We did have a note here. We're having a request. These jurors have actually been here for quite some time. Request for a restroom break. We're going to permit that at this time. So we'll take about a 20-minute recess and time for the jurors to use restrooms if they need. We'll come back on the record once that mid-morning break is concluded. Please rise for the jurors.
All right, wait.
Oh my word, y'all.
You can leave them there on the chairs. Yeah.
I will say this, because I was literally sitting here thinking, I'm like, I would have gone to the bathroom 3 or 4 times at this point. And they haven't even gone once, right? There's no way. I would have been like, I would have raised my hand. I'm like, I have to go to the bathroom. I'm sorry, y'all. I mean, here's the thing. Yeah, I mean, and I'm not being dramatic, I don't think, when I say this, but as we get, I mean, I'm in my 40s. There's just stuff that sitting in a chair like that, not, I'd be like, can I have a beverage? What about the bathroom? I mean, there's just things that it's not like when you were younger and could, you know what I mean, be in an uncomfortable situation for hours on end. So I mean, I'm making jokes like I need a cot to lie down, this and the other. I mean, but there's a certain level where I'm like, I mean, come on now. You know what I'm saying? I mean, come on now. The bathroom being the first one. I was hanging out with a friend yesterday and I was like, literally, I was like, yeah, I like at work, I would have gone to the bathroom probably 4 times to people's 1. Like, that's just, now, mind you, you see that big thing of water I drink too, but this is even before that. That coffee is so good, y'all. So, yeah, but so back to Pryor. I mean, he's annoying, all that kind of stuff, but it's like, I mean, I see what he's doing and I get it. And again, if you follow the first trial with Laura, I mean, this is his vibe. It is no different. He is on brand, right? He gets in there, he's a talker, the whole 9 yards. So it's like, this is just what he does. But as you see, he's gotten them all riled up. He's just vetting them out, you know. Whereas the state was a little bit more softer around the edges. And you know what I'm saying? Like, they were getting some things done. You can kind of see already, listening to some of their responses, that it's like, oh yeah, I wouldn't want them on the thing. Like, they didn't speak up till now. And he's going to get under people's skin because that's what he does. Like I was saying, I think I said in a comment earlier, he lulls you. He kind of like talks to you, makes you think things are friendly, and then he goes in for the kill. You know what I'm saying? So I know, right? He really is a leech, isn't he? Yeah, I mean, he's gonna come in and just bang his way through everything. It just boom, 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 boom. Yeah, that's just what he does. But as you see, he got them talking, and then the more they talked, the more they said, and it's like, okay, so you don't want to be here. Because I mean, he does have a point of like, who doesn't want to be here? I'm like, well, of course not. Everybody would rather be at home, this crowd taking care of, 4, 5, 6, 7, 8, 9 kids, I mean, that alone, I'm just like, oh my God. Dang, Alley Cat, I'm 31 and can hold my pee for 12 hours. Go on, girl. Chronic chain smoker, IBS, good excuse to avoid. Yeah, now that's the other thing. I used to be a smoker, and I want to sit here and think, how would I make it through if I was a smoker? You know what I'm saying? Like, that's the other thing where I'm like, just like you saw with Alec Murdoch's thing, where some of them were like, oh, they said that we couldn't make a decision or we couldn't smoke until we you know, came into a decision. And I'm like, yep, that would do it for me right there. Yeah. Oh, so the same thing. If I move around, it's worse. Having to go to the bathroom. If I'm just like sitting there, it's almost like you can tell, but because your body's not moving, the second you're like, it's like, uh-oh, gotta go. Isn't it wild, all the different stuff? Yeah, Kylie says, smoke in the hall. Letitia, stop trying anyone. Pardon me. How many different things happened in these trials and stuff like that? It's crazy. So yeah, I don't know how many weeks they've set aside for jury trial. Oh, let's see what Nate Eaton's saying. Hold on. Let's go to his thing. Please hold. Wood tells jurors they may think some laws are unfair, but they need to follow the law as it's given by court. He asks if they agree to hold up their cards. All of them raise their cards, but one juror says he has an issue with the death penalty. Okay, 6 minutes. Blake has to approach the judge. Sidebar is called, and white noise plays in the courtroom. We're taking a 15 to 20-minute break. Jurors agree. Prior asked if jurors believe law enforcement could be swayed or influenced. A few raise their cards. Prior questioning a juror whose father was a police officer, he explains that officers can be influenced or swayed or could have an agenda. Would you agree that police officers' role is to investigate the facts and report the facts? Everybody agrees. A reminder that Pryor has represented Chad Daybell alone. He has never done a death penalty case and very little criminal work. Lori Vallow had Chim Archibald and John Thomas, 2 death penalty qualified attorneys with years of experience. Yeah, he's going to, I mean, my God. I didn't know that part. Hold on one second. Hold on, let me respond to this. Thank you, Abilis. I hope I said your name right. Okay, sorry. So this is my thought process on all the stuff's going on. It depends when they go, but at 2 o'clock, I'm going to knock off here because I got to get some stuff done here and go help some people with moving and stuff like that, and then do some more YouTube stuff. So at 2 o'clock, I'll end the stream here. I don't know how long they're going to go to their lunch break. If they're going to take a lunch break, I don't know. So we'll see. So just heads up for everybody. That's kind of my plan for today. Oh, cool. Thank you. Yeah, he didn't get, Mel says, Paul Pryor has known this is a DP case for a very long time. He didn't get a qualified lawyer because of his ego. It makes total sense. Let me respond to this. Okay. Yeah, that's the other thing. I mean, so we're in the comfort. I mean, I don't know about y'all, but I'm in the comfort of the sofa, and I'm like this over here. I'm like, now, mind you, I'm not. It's different when you're dressed or in public. I get that, right? But I mean, my gosh. Yeah, Stormy says that she can take the second shift and stream depending on what time they come back. Yeah, this is kind of how it's going to go. Like when I stream this, like if there's days like this where I have the day off and I've got a few, hours here or whatever, absolutely. because I work and I got stuff going on and whatnot. But this, I mean, I've been so eager to get justice in this case, and we got Lori out of the way. Now Chad, so I definitely want to do as much as I can. You know what I'm saying? I do appreciate it, Carol. Actually, he was going to get the case thrown out because the state taking too long to hand over evidence. Now he's going to stick this out. Yeah, he's going to. Excellent point. Yeah, he's going to. He probably wasn't really planning on being here. You know what I'm saying? Bye, Zelda. What time is it there? So where I'm at, it's 1:07 p.m. Hey, Crochet. And I believe they're 2 hours behind me. So I think it's 11. I think it's been going for a couple of hours. I would imagine they'll probably do another 2 hours before taking lunch. I'm sorry. Thanks, Connie. I appreciate it. 10:07. Are they 3 hours behind? Or is that where you're at, Zelda? Oh my gosh. Lily says, I served as a jury in a civil 6-week trial, and there was a juror who would walk into court with a blanket. And when we sat down, she would take her shoes and fall asleep. I mean, that would be almost me. 12:07 in Texas. Woohoo. Pacific Northwest. Okay. Mary says, I want someone to check into R&E's internal organ damage. Wait, are you going over to the Ruby and Jody case? R&E? Yeah. There's no telling what kind of long-term physical. I mean, I hope that they've gotten proper medical, you know what I mean? Like they're continuing medical monitoring, I guess you could say, because of the stuff they put them through with like no water and the food withholding and stuff. Noon in Missouri, Isle of Wight, 1808. This is my mental long-term and isolation is highly extreme. Yes, agreed. I agree. So for those who are just joining or new or whatever, what's going on is we are watching the Chad Daybell trial. It's day 1 of jury selection. They are on a current break right now. They are on a potty break for the jury. Where we left off with is John Pryor, the defense attorney, is vetting and going through and doing his jury selection. We're still on the first group of people, and we're still in the first group of people. So yeah, I mean I don't know how many they have to go through. I mean, I guess until they get. I mean, but look at this. I would think that they've done 2 weeks. Because imagine this, if you could get 2 jurors a day, well, I mean, you want more than that, right? It just depends, right? It just depends. I personally think, yeah, Kylie, I agree. I think this process could take several weeks. I don't see how it could take less than. Stormy says, yeah. Yes, Stormy. Yeah, absolutely. I don't know if you can drop it in here. Hold on, let me go in here. Hold on, video. Please hold. Please hold. Wait, let me get down to this. Oh, Lord. Okay, here we go. We're Stormy. Shibby dooby 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 dooby. Okay, we are. Stormy's going to be going live after here, y'all. If anybody wants to jump over there. And there's I just dropped the link up there above. It depends on how long they take. to get back. I mean, this is, I mean, like I said, this is, I mean, again, they haven't even gotten through this, y'all. It's only 1:11. I mean, it is what it is. I mean, justice takes time. It's interesting too to see how slow the process can be. It's like all of a sudden, bam, now you're here. But I mean, what you see, I mean, this has taken years to get here, right? So yeah, it's just, oh my goodness. It takes a minute. So for other people who are just joining or looking at other stuff, Alec Murdaugh was sentenced to another 40 years today for more of his financial crime. So there is that. Okay. So got 40 years. Got a lot of stuff going on in a lot of stuff coming to a head in true crime. I'm going to try to record another installment of whatchamacallit, of the diary thing today, the journal thing for Ruby. So we shall see. We shall see. Oh, wait, hold on. Let me respond to this. Yeah, the Ruby and Ruby's journal just gets worse and worse. I mean, I'm just like, my God. I mean, that one this morning, I'm like, what? I mean, it just keeps getting worse and worse and worse. Tell the story. You know what? I might do that. I might do the reading part for that. On the next one that we do, when I have a little bit, because I'm not gonna lie, y'all. Right now, I'm like this. I'm like, I'm not gonna lie, y'all. I probably want to do it the justice, meaning like put the comedic spin on it it needs. If that makes sense. Satan's Bride. Oh my God, I know. Dear G. Yeah. Orly says, do you think Alec has resigned himself that he'll never get out of prison? I mean, you would think at this point, right? I mean, you would think. I mean, my God. Dramatic role what Joey's possession looked like. Here's the thing with her possession thing when he was talking about it. I was like, the things that these people will do, number one, for attention and to grift or whatever it is she was doing. I'm just like, and again, I can't get past the fact that he's like, well, if she was faking it. And I was just like, dude, you know, those cops' mouths fell on the damn ground when he said that. Well, if it was real, if it wasn't real, and they're like, they're like, immediately take the remaining children away from this man. Immediately take them away. I mean, absolutely take them away. Check out my video from 3 years ago. Who's chat? Wait, hold on. Let me go over here. Hold on. Hold on. Where's my little channel thing? Where's the chat? Zelda. Boom, boom. I said, boom, boom, boom. And he said, way out, way out. Boom, boom, boom. And he said, way out, way out. Okay, I should be. Okay, I got it pulled up. I'll check it out when I'm done on here, Zelda. Oh, wait, so do you live in wait, am I correct? So you live out in Portland, or is that, am I wrong? Right? Oh wait, I think we got, do we have volume? Oh, here we go. Oh my goodness. Yeah, I'm going incognito again. They might have told John Pryor to zip it. Yeah, thanks y'all for joining.
All right, great.
Scared me to death. Here goes John. Oh, good Lord. Come on, get the jury in there.
Go back there. Thank you. Please be seated.
Okay, I'm going silent.
Okay, we're back on the record. Mr. Pryor, you can continue with your board hour examination. You may.
Before I get into a different topic, do any of you folks know each other? Nobody knows each other? Yeah. And again, remind me, in terms of media viewing, how many of you have seen anything of it? Whether it's the internet, TV, anything like that, raise your cards if you've seen anything. Okay, thank you. One of the instructions that the court's going to give you is that it talks about what a conspiracy is. And the state talked a little bit about that. Prosecuting attorney, I think, but please forgive me, I believe it was Ms. Blake. Talked to you folks a little bit about that. And one of the things in order to have a conspiracy per the court's instructions, and this is what the judge is going to give you as rules, okay, is that there needs to be an agreement. There needs to be an agreement. Is there anybody who doesn't understand what an agreement is? Okay. Juror number 219. Sorry. How do you define what an agreement is?
Hard to define without using the word agreement. Basically, you're understanding the same thing. An individual that you are working with on.
Juror number 11, we haven't picked on you, but I apologize if we picked on you. Okay, that's okay. Okay. But what do you think an agreement is? How would you define an agreement?
I would define an agreement as two or more parties formally agreeing to something or seeing like one another and formally, planning something together.
Is there anybody who disagrees with that? How about hands of showing me anybody who agrees? Hands or cards, whatever you feel. So if I understand it, 394, did you put your card up or hand up? I'm sorry. Okay, so you think that there needs to be a formal arrangement. How is that arrangement set out? Is it in words to each other saying, we agree that this is what we're going to do? Is that how you reach a formal agreement?
I think it varies based on the situation. I think it can be formal, it can be verbal, non-verbal, just depends on the situation.
Okay, but there has to be some, I don't want to use fancy words, and I tend to speak very simply. It has to be some kind of a statement or something that says, yeah, we're all in on this, right? Juror number 27, what are your thoughts on that? I'm the one who struggles with technology.
Yes, I would agree with that. think based on what you're coming to agreement of, there might be different protocol.
Okay,
But I believe your word is your word, regardless of what that protocol is.
Okay.
So if you're coming to an agreement, then you are to agreement, that's your word, that's your contract, essentially.
and we're gonna work our way down to juror number 31, and she's smiling. She looks like she's ready to let me know her opinion, so I'll give you this chance.
It's a nervous smile.
Oh, I'm sorry. If you're too nervous, we
No.
can pass the mic on. In fact, folks, if it gets to the point where you're too nervous and you just don't want to say anything, this is like a game. Just pass it on to the next person. You know.
No, I'm okay. It's
Okay.
being that I don't. An agreement, I think too as verbal, but sometimes it's a written agreement.
Okay.
Not necessarily, I agree to that or agree because even though you say it, doesn't mean it's for sure.
Right.
Or if it's written down, a signature or something that I feel like you can't get out of that agreement now.
So if people are just talking about topics, that doesn't necessarily mean it's an agreement, does it?
No.
There has to be some, and I'm going to use a fancy word because I'm surprised to you, I went to law school. And the one thing they do to us is they try to put fancy words in our mouth. So I'm going to use this fancy word, but I'm going to ask you to maybe explain it in what I think are simpler words. They say you have to manifest a desire to agree. Would that be fair?
Yes.
Okay.
Yes.
Pass it on to our friend number 41. What do you think? An agreement. What constitutes an agreement? Would you turn that on? I'm sorry. Aside from that being technologically advanced, I can't hear very well either.
So. Well, everything we've all said that you agree with is between people and.
Okay. So you would generally agree that there at least has to be some sort of arrangement or understanding between all of the parties that this is what you're doing. Does it have to be really clear? Or can it be, well, I'm not sure.
We approach.
Well, in the interest of time, this way, is there objection the state has?
Your Honor, the state's position would be he's misstating the law and what the, at least the IPG would be. In this case, of course, we don't have the specific instruction from this court, but I think he's confusing the elements of this particular crime.
At this point, Mr. Pryor, I am concerned that we're delving into court instruction here and outside the scope of what Rule 24B permits on juror qualification. And so I would ask that we move on from definitions of what an agreement may be in the case. The jury will be instructed on that issue.
And Judge, can I respond to that objection just to get a clear record?
Yes.
And Judge, the state took some time to talk to the jurors about, speaking honestly and straightforward and all of that. And I think quite frankly, I'm allowed to go into at least what they're understanding, because these folks are going to be providing jury instructions. And those jury instructions, at least from my perspective, I can ask them how they would understand and interpret that. So I'm, all due respect to the court, I disagree.
All right, well, I stand by the ruling. Instructions will clearly delineate the elements of any crimes charged in the case the evidence may show. And I think this is going beyond the scope of proper voir dire, so if we move on to another topic, Mr. Pryor.
Is there anyone here who can promise me that they will review the entire evidence before they make a decision? Please raise your cards up. Is there anybody here who thinks that they just need to look at the prosecutor's evidence? And if they've already figured out what they feel on that, that they don't, it's really not necessary to listen to my evidence. Anybody agree with that? Okay, all right. Judge, I think that's all I might have at this point. I think that's all I have. Thank you, folks. Thank you very much for your time.
All right, thank you, Mr. Pryor. We'll move on at this point. We are going to have some individual questioning of jurors. I did want to return back around with a question or two of my own, going back to juror 296. We talked a little bit about hardship. You've raised a couple of different things. I'm sorry, juror 394. Apologies. there's you've got an important trip planned the very first week of June, is that correct? All right, you've also made some concerns about your work situation. On the June trip, I guess on each of those points, number one, I don't know that we'll have an opportunity to go back and, for example, check with employers, find out what that answer is. We'll kind of need to know today whether you're in or out potentially as a juror. So we really need to go on the information we've got now. The second point I guess I'd make is if this case is going longer than anticipated and we're getting up to June, do you believe that would become a severe distraction for you if you started thinking you were not going to be able to attend this vacation, or do you think you could possibly set that aside?
Yeah, I wouldn't consider vacation hardship. I would really focus on the case. So.
Okay, I just wanted to be clear on that. So I appreciate your response on that. With that in mind, then, at this point, we are going to conduct some individual voir dire, and we've got a process. You're the first group we're doing this with, so we've thought it through, but the process will be to have jurors remain one at a time. And so you'll cycle in and out of the room while we have one juror remain for this individual section of our questioning. At this point, then, we'll go ahead and start with probably the lowest numbers starting first. So juror 27 will remain for some more individual voir dire. The additional remaining jury in the panel will be excused for a moment while I talk to them, and we'll go in that order.
All right, please. Number 11.
I apologize, it's 11. I saw the empty seat there and thought one had been excused. Thank you. Thank you. Please be seated. All right, juror number 11, we do have, I believe, a response in here. You've got some knowledge of this case previously. I don't know that you raised any concern as it relates to possible hardship. So at this time, I've just asked for counsel, beginning with the state and then the defense, to make any inquiries you think are necessary in order to go into the issue of potential bias from pretrial exposure. Who's going to be doing that for the state?
I will be on this particular juror with juror number 11.
Okay, thank you. So Ms. Blake, if you'd like to confine the response or your voir dire to that topic of potential bias, and then I'll allow the defense, and then we'll move on to questions on death penalty responses after that, and I'll have my own questioning.
And Your Honor, in regards to juror number 11, the state's only real questions are going to be regarding hardship. We just wanted to clarify a few things. And I will indicate there was no hardship listed, just with some of the responses. We just wanted to verify a few things.
Okay, you can go ahead and inquire on whatever topics then, Ms. Blake.
Thank you, Your Honor. Juror number 11, it's my understanding you have a brand new baby, 3 months old.
Yes, I do.
And then you also work. And I know that you indicated no hardship. I just wanted to clarify with you, do you work nights?
Or early mornings.
Okay, so coming here by 8 to get started at 8:30 or maybe even sometimes a little before 8, would that create any kind of a hardship for you?
Not immediately, though.
And when you say not immediately, just so I'm clear with you, and I apologize to put you on the spot here. In not immediately, would you be good for a full 10 weeks or for the expected duration of the trial?
Yes, I can mix it.
And do you think your employer will work with you on that?
I have talked with my employer about it, and the transition will be a little difficult, but we could work out a compromise.
And it sounds like they're willing to work with you then from your conversations?
Correct.
And then with that 3-month-old at home, do you have any concerns if you were to be sequestered for a period of time?
It would be difficult being away from family, especially with a young child at home like that, but if it is required as a specific duty, I would be able to make it work.
I just wanted to verify that with you because I know sometimes people don't mark a hardship down because they try to compare themselves to other people's situations. So I just wanted to make sure that that was going to work for you. And then just to clarify with you, my notes from the questionnaire that you filled out was that you really didn't have any prior knowledge of this case. Is that correct?
Correct. I just heard about it in rumor.
That's all the questions that the state has. Thank you.
All right, Mr. Pryor, you can inquire on voir dire. I note there was a bit of a mention of some pre-case knowledge as well as those hardship issues. If you'd like to inquire on those two topics, then we'll move on to questions as it relates to the death penalty.
My notes say that you saw media. Did you hear about this by way of media or not?
I came across it just looking through the news, but I never delved any deeper than glancing at it.
Okay, and please forgive me, I don't mean to delve into your personal affairs. Would it be a financial hardship for you to support your family being off for 10 weeks?
It would be difficult. I'm still communicating with my employer about their policies with jury pay, but if it was unpaid, yes, it would be a financial hardship.
And that's really what I want to get into, is that, we all have an obligation to members of the jury and serve.
Mr. Pryor.
And I'm sorry. Is that better? No. We all have an obligation to serve, but if it gets to the point where you feel like this is going to be a terrible financial hardship and you're going to have to struggle financially, at that point, this is not supposed to be something that imposes a significant burden on you. And what I'm understanding is that if your employer, I know your employer, I know you work, we don't need to get into that, but that employer doesn't pay you for more than a week, this is going to be a significant financial burden on you, isn't it?
Yes, it would.
And it's going to be difficult for you to make your expenses and your needs to provide for your family.
Correct.
So we're sort of banking on the fact that if your employer doesn't give us the right answer, you're going to be in a different situation. Do you agree with that?
Yeah, I would agree. It does bank on what my employer does say.
Okay, and at this point, I don't need you to be noble. None of us should be noble. I feel like if someone had asked me to take 10 weeks away, yeah, I think I could do it. But if it's going to be a situation where you're going to have to, after 10 weeks, you're going to have to play catch up and you're going to have collectors and things like that, that's not being noble. I mean, I think at this point, if you really feel that this is going to be a financial hardship, if your employer doesn't give you the correct answer, I consider that a hardship. Would you agree with that?
I would agree.
Judge, I'm going to vote for cause. I think this young man is being honorable, but the reality is that he doesn't know what his employer is going to say. And quite frankly, it's going to be a financial hardship, and now's the time to resolve this rather than waiting until we get into the next round.
Response from the state on the challenge for cause.
Your Honor, with that additional explanation and information, the state has no objection.
All right, well, turn number 11, the court will agree with counsel agreeing as well. Your attitude is very much appreciated by the court and your willingness to serve. Congratulations on your new family. I hope things continue to go well for you at work. And at this point, just given the length of this trial and your situation, it is a concern that you may face an undue financial hardship. So you will be excused and the court will support the strike for cause on a hardship basis for jury number 11. So that will conclude your jury service today. Thank you for coming out. All right, and Mr. Bailiff, if you bring in juror number 27 next.
Yeah, sure.
Just the process of waiting for the next juror to come in and out. I'm like, oh my God, y'all, there's just, I cannot. Yeah, daycare Karen is still there. So for people that are just joining, the biggest drama, and it's not even drama, but the most interesting thing is we have a daycare Karen in the jury poll who I'm very curious why she'll go after.
All right, thank you for returning here to courtroom juror 27. We're going to conduct an additional individual voir dire with you concerning issues of either bias or hardship, both of which were mentioned in the questionnaire. Although the hardship was checked as a no, and you potentially have a vacation starting June 15th, it looks like. The question of prior case knowledge is something I think we need to explore a little more outside the presence of other jurors. So I'll begin again with the state if you'd like to conduct any additional voir dire as it relates to pretrial publicity or bias. You can do that, and then I'll allow the defense.
And just to start, juror 27, have you ever lived in Florida? Okay.
No.
And so this may seem like a strange question, but just to double check, have you ever been charged with a crime in Florida?
No, I have not.
Okay. Okay. In your questionnaire, you mentioned that you've seen some headlines.
Correct.
But you didn't really read, if I read this accurately, you just looked at the headlines and didn't really research the case.
No, I never clicked on the headlines to read any details.
Okay.
Not headlines.
So you knew that something was going on, but you didn't know the details.
Correct.
Sometimes headlines can be, for lack of a better word, loaded with a lot of information, maybe designed to make you want to read it. Was there anything in those headlines that may have biased you towards this defendant?
No, sir. Don't think I could make a judgment based on a media headline.
Okay. And so, whatever you did see in those headlines, you can commit to this court and to this defendant and to people of that you can set aside whatever you saw in those headlines and give this defendant a blank slate for this trial.
Yeah, absolutely.
Your Honor, I don't have any other questions on media exposure. If the court wants us to go into that penalty section at all right now, or
I'll do an inquiry on that starting and then allow you questions as well. I guess the only question I had while we've got you here is the vacation starting June 15th. We're scheduled to be done at that time, but if this were running long, would that start causing you some great concern if you were potentially going to miss that?
No, there is a vacation on the 24th that would cause me concern, but the one on the 15th is flexible. It could be moved.
Okay, that's the only question I had on that. Mr. Pryor, if you'd like to inquire as it relates to bias, you can do that, and then we'll move on to questions regarding the death penalty.
And ma'am, the concern that it's much like a number of the other folks, there are 4 kids at home. And forgive me, I can't remember the ages of those kids. Younger kids?
My children, my oldest is 12, and then I have 10, and then I have twins who are 8.
Okay, and are you the one primarily responsible for taking care of those kids?
You could say that my husband works from home, so he is around always.
So there is some flexibility there.
There is some flexibility, yes. I homeschool my kids part-time and they go to a program part-time, but my husband's always home and he's very involved in the homeschool process.
So he could take over at least for 10 weeks. I saw that in the file. I couldn't remember exactly the age of the children were. But I saw that there was a homeschool issue. I don't recall seeing the husband take that over. That's something you folks can work through.
Yeah, I mean, it would take some logistics and compromise, but it's definitely doable.
Okay. All right, now, Judge, I don't think I have anything else.
All right, thank you. So juror number 27, the next topic we're going to discuss as it relates to capital punishment, which is a factor in this case. The first question I guess I'll begin with is, do you recall answering, and you do have a copy of the questionnaire there, but these questions on part 5 of our questionnaire called attitudes regarding the death penalty. Do you remember answering those questions?
Yes, I do.
And to your best recollection, are all of your answers in the questionnaire still true and accurate about how you feel about that today?
Yes.
Okay. So in this case, juror number 27, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. In this case, looking through your questionnaire, you've indicated that you are in support of the death penalty. Is that still accurate?
Sure.
I'm going to read another statement to you now. Remember, any penalty you consider should be done as if it is absolute and will be carried out in this case. Your conscientious, religious, or other objections to the death penalty are not grounds for you to be excused as a juror. Do you understand that?
I understand.
Okay. And based on your responses, would you be in favor of the death penalty in every case where a murder has been committed, or would you follow any instructions given by the court as to whether or not it should be applied?
Follow directions of the court.
Okay, so you're not saying you believe it should be imposed or you would vote for it in any case?
Do not believe that is the result of any case. Correct.
All right. Having considered then the responses in the questionnaire here, the court is going to pass over voir dire for any additional questioning from the state at this time, and then I'll allow the defense to voir dire on that issue.
Your Honor, the state doesn't have any further questions.
All right, Mr. Pryor, any questions?
Judge, would the court prefer that I be up at the podium, or are we okay for me to sit here?
You're fine to remain seated as long as you talk into the mic.
Thank you, Your Honor. Ma'am, there's no wrong answer when it comes to people's feelings about that. Everybody has an opinion, and everybody's entitled to their opinion.
I agree.
Okay. One of the areas that caused me to look at your particular profile nothing more, but in your case, you have 4 relatively young children. If you were to hear testimony that related to the death of young children, would that cause you to react in a way that would say, there are children involved here? It has to be the death.
No, honestly, age doesn't, the death of anybody is sad. I don't believe that I would be affected just because of age.
Okay, and on the same token, if someone's immediately convicted of a charge such like this, is that an automatic for you for the death penalty?
No, not me personally, no.
Do you start at the death penalty and say, well, I'll look at other things, but it's been a murder, so we're starting at the death penalty and then we're going to work backwards?
No.
Okay. Judge, I have nothing else. Thank you, Your Honor. Thank you.
All right, I just have a final question then for your 27. So as we get into that section of the case, are you committed that you would hold the government to its proof in this case if that was the instruction you were provided?
Really?
All right, thank you. Juror number 27, you can go ahead and return to the jury room there with the bailiff, and we will next have juror number 31, Rod.
Okay, y'all. So in 12 minutes, I'm going to be signing off of here. Just heads up. Emily, I hope you're doing well. Thanks for joining. So that'll be it for today. Obviously, it's going to keep going on, but I have to go do stuff at that point. I'll be very curious to follow up to see if Daycare Karen makes it to the cut, because like you saw, she made it through all the questions, right? So it's like, okay, now I assume that at the end they have who has made it through there, and then they come back maybe and go through it. I'm not sure how it works in every different place, but hold on, do they have them up there? But we'll see. Well, it's taking this one. But they have to go out there and get them. I mean, here's the thing: the dude with the 3-month-old, there's no way. I mean, you want to take 2.5 months out? I mean, I can only imagine.
All right, juror number
Here we go.
31 is now seated. The court's going to take just a moment to briefly review again the questionnaire. All right, the court has determined an individual voir dire to be appropriate for this juror number 31. This particular juror has some knowledge of the case, which we'll discuss with you here individually. I'll allow questioning on that. There's also a potential personal knowledge of one of the participants in the trial, being my staff attorney. And then in terms of hardship, there was nothing there. So I guess let's start with questioning in terms of any potential bias. And after that, we'll move on to questions as it relates to the death penalty and her responses in the questionnaire. So just as an outset, you do have a copy of your questionnaire there with you. Are all of the questions that you answered and your responses, including on the section of your attitudes regarding the death penalty, are those answers still true and accurate to the best of your knowledge here today?
Yes, sir.
Okay. Well, with that in mind, I'll allow the state to inquire first as it relates to any possible bias, then the defense, then we can move on to questions related to the death penalty. Ms. Blake or Mr. Wood.
It's me, Your Honor. Ms. Rainey.
Ms. Rainey, sorry.
Thank you.
Go ahead.
Good morning. I want to talk to you briefly about some of the media exposure in this case. You mentioned in your questionnaire that you had seen this case on the news.
Yes.
Yes. And you also mentioned at one point, there was a question on page 19. Has any of your possible exposure to news reporting caused you to form an opinion about the defendant's guilt or innocence? And you had written that you weren't sure. I believe you wrote, "I don't know." Can you kind of talk to me a little bit about that?
Because what I have seen and when this all started, I was there. But until I actually see the evidence and hear more of the background of why I didn't, that's when I feel like I will know more than just what I've seen on TV.
Okay, well, that kind of leads into my next question. Because you had also mentioned that you were hoping that you got to hear the correct story from them both. And so during this trial, you're going to be instructed by the judge that the state, the prosecution, has the burden of proof, and the defendant does not actually have to testify at all. That's the state's burden of proof.
Right.
And so is that something that would trouble you?
No.
Okay. And would you be able to set aside what you've heard in this case on the media and just let the defendant start with this clean slate presumption of innocence and wait until you've heard the evidence to make a decision?
Yes.
Okay, thank you. And then just briefly, in the hardship portion, there was a question about being sequestered, and you mentioned that you have concerns. Is that something you'd be comfortable talking a little bit about or elaborating on?
What one was that?
I believe it was on page 21, and it was a question about being sequestered. And you had written, the question was, would any potential sequestration pose an unmanageable hardship for you? And your answer had been, maybe away from home overnight, I do have concerns.
Okay. So yeah, I didn't know. A long time away from home is just a long time from home.
Sure.
My husband's on disability, but we're just so used to doing everything together 24/7, where I just thought, gosh, weeks after weeks after weeks not seeing him, that'd be hard. But I mean, I would do it. That was just kind of my.
And does your husband have a disability that requires your care physically?
No,
Oh,
no.
I don't believe I have any other questions at this time, Your Honor.
All right, thank you, Ms. Beatty. Mr. Pryor?
Yeah, I only have a couple of questions. Thank you.
Mhm.
I only have a couple of questions. I wouldn't be able to do without. I saw on your questionnaire, and I'm talking page 7, the bottom of page 7. Let me know when you're ready.
Okay.
Under part 4, number 1, question A. Oh my gosh, that's a mouthful. It says, do you feel that a defendant should be required to testify? You are yes. Could you elaborate on that a little bit just for me, just so I understand?
Answering this in last week, and then listening to the different things that they really don't need to testify, that I feel like if I heard him testify, I don't know if it'd make change my mind whether he's guilty or not guilty. I'm aware that he probably won't say anything that I learned today. So it probably would not matter at this point.
But when you marked it,
Yeah, I marked it yes.
you should be required. What I'm concerned about is not what you're hearing today. It's just that when the case is submitted to you and it's all over with, are you going to be able to look beyond that opinion of yours and say, well, I originally said, I think he ought to testify because I really want to hear what he has to say. But I guess that you can understand that could be a concern.
Right,
Right.
right.
And that's a legitimate concern. Would you agree with that?
Yes.
Yeah, so I guess I'm just sort of wondering if you'd be able to look beyond that and say, okay, I don't need him to testify. I can evaluate the evidence as it's presented to me without hearing from him. Would that be fair to say?
That's fair.
Okay, thank you.
Yeah.
And then lastly, under B, right underneath that one, you said, question was, do you feel that a defendant who does not testify is probably guilty or has something to hide? And you marked yes. So I understand you said you could look beyond that. I guess my concern is that do you still believe that if he doesn't testify, or that if any defendant doesn't testify, maybe they're hiding something or they must be guilty?
I should have put no, because reading that now, no.
Okay, and I understand
Yeah.
the stress of being in these situations. You know, you're trying to get this done and you've got a million things on your mind, and maybe you just, are you suggesting you just overlooked it? Or you-
I didn't read it correctly,
Okay,
so.
okay. So, and then finally, again, and I don't want to get on too much into your husband's disability. Would it be fair to say that he's you're his emotional support in terms of being home with him, and that there would be some sort of loss of emotional support for you not to be with him for what could amount 10 weeks, almost every day of the week, exception Saturday and Sunday? Is that going to be a hardship? I guess I really want you to be focused on this case. I really want you to take the time to read everything and be clear about what you're reviewing. And what I'm really concerned about when I hear about family members who have to struggle with disabilities, it's a terrible thing to have to deal with. I just want to make sure that you're going to be able to focus and you're not going to be overly concerned about your husband, and because this is going to be a 10-week job for you.
Right,
And it's a significant job.
right.
We're
I
here on
understand that.
We're here on a very serious situation. I guess I want to make sure that you're going to be okay, because ultimately, it really needs to be whether or not you're okay. It doesn't need to be whether I'm okay or these 4 prosecutors over here are okay. It really comes down to whether you're going to be okay. I just want to make sure that you're okay.
I'm okay. Yeah.
Judge, that's all I have. Thank you.
Okay. At this point then, juror 31, I'd like to just turn to the topic raised in part 5 of this questionnaire, and it's titled Attitudes Regarding the Death Penalty. I'll walk through a couple of your answers with you here. You did say that you support or oppose the death penalty. You said oppose. And then, do you feel your views on the death penalty would prevent or substantially impair your ability to view the facts impartially? You said no. And the next question, would your views on the death penalty prevent or substantially impair your ability to return a guilty verdict to first-degree murder, even if the state had proven its case beyond a reasonable doubt? You also said no. So in this case, it may well be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. So looking at your responses there, I'll first let you know that any penalty you consider should be done as if it is absolute and will be carried out in this case. Your conscientious, religious, or other objections to the death penalty are not grounds for you to be excused as a juror. Do you understand that statement?
Right, yes, I do.
Okay. So going back to your answer then, having thought about it, although you may be opposed to the death penalty, you've also indicated it would not prevent you from either rendering a verdict if the state proved its case beyond a reasonable doubt. Do you still feel that way?
Yes,
All right. And you've also said it would not substantially impair your ability to view the facts impartially. Do you still stand by that answer?
yes,
Okay, so even if you have a personal view opposed to the death penalty, do you believe you would be able to set aside your own view here and follow the law and instructions given to you by the court in this case if you were instructed that you had to consider that penalty?
yes, sir.
Okay, that will conclude the court's line of questioning as it relates to her responses on the death penalty topic. The state may inquire on that issue at this time. All right, does the defense have any questions for the juror on that?
No, Your Honor, I appreciate your inquiry.
Okay, that will conclude then the individual voir dire of juror number 31. You can return to the jury room there, and we'll have the bailiff next bring in juror number 41.
Okay, y'all, so I am headed out. This has been fun. Thank you for joining me. Again, this is kind of how I'll be live streaming this from over in the podcast channel here, is when I have time and I'll just poke it up. It'll kind of be unannounced or announced at times, so just be on the lookout. Make sure you're sub, check the community tab. Thank you everybody for the conversation, for keeping it cool, for your patience getting through this, for the super chats, for the laughs, for the everybody being just all overall wonderful. I appreciate it. And that's it. So Roscoe's sleeping down here, but he does say thank you, and he'll see you tomorrow, whenever it is. But that's it. I love you guys. Thank you so much. Thank you, Emily, for holding the fort down. And I will talk to y'all later.